Thank you everyone for coming. All right, thank you everyone for attending today's Junior Faculty Forum workshop. We have a very interesting paper for discussion today by Animesh, who is Assistant Professor of Law at St. Xavier's University in Kolkata. The paper is on changing dimensions of investor-state dispute settlement in India. And the subtitle speaks about whether we're protecting the regulatory power of the host state. This is obviously a pretty important issue, and it's very interesting to see a paper that's looking at it in India and from a comparative perspective. Our two discussants today are Professor Jarrod Hepburn of Melbourne University and Professor Eric De Brabandere of the University of Leiden. I'll just briefly introduce both of them. Professor De Brabandere is a Professor of International Dispute Settlement Law. He's also the Director of the Grotius Centre for International Legal Studies. I think anyone who works in this area will be very familiar with his work and we'll be very grateful to him for making the time today. Professor Hepburn similarly is at Melbourne Law School. He does work in the area of international economic law and as well as international law more broadly. He's done a particular work on looking at international investment arbitration. I think his book on the topic is probably on reading lists around the world. So again, thank you, Jarrod, for making the time to attend today's session. Without further ado, I'll just hand over to Animesh. We don't do a formal paper presentation. Animesh will briefly summarize what his paper is about, and then Eric and Jarrod will give comments on the paper, after which we'll have a more general discussion.
Thank you, Professor Arvind, for generously giving a nice introduction to those whom I iconize. I am really, my heart is pumping because the paper is being written down after extensively reading both Professor Hepburn's and Professor Brabandere's work. And the recent paper, which I'm working as well on human rights and investment arbitration, which is again influenced by Professor Brabandere's book on human rights and investment arbitration. Thank you so much, both of you, for generously accepting our invitation and accepting the invitation to give comments on what I have written. So without much ado, I'll just move on to what I have written in a very brief manner. India after 2015's model BIT, what we have seen is it has moved towards a system which does not allow investor arbitration to the fullest, as it was the case before 2015. There are certain jurisdictional limitations and other extensive restrictions which are imposed on foreign investors who have started to invest based on the new model BIT. And we have also seen that how 57 BITs, even more than that at later point, were terminated unilaterally by India. So under such circumstances, what I understood after reading the existing literature, that there is a point where we can work and criticize the stand that India has taken with respect to protecting its regulatory freedom and space, and thereby mostly in the cases where we have seen that because of the regulatory measures, India faced serious compensations in the past. So it has taken that step. And the last BIT in 2020, which it entered with Brazil, though it is not clear whether it is going to follow such a template, but at least apparently it is quite clear that India has moved out from its normal system of keeping both ISDS as well as SSDS. Now it is only moving towards SSDS with the Brazil-India BIT. So is it something which India is purposely doing to protect its regulatory freedom based on the previous cases, or is there a story behind, or is there something that we can even find out at a later point of time? With that, in the paper, I have also tried to include the point that whether this is a right time that India could include ICSID in its consideration, because there is no forum as such left for the foreign investors to invoke in cases of ISDS, because we have a heavy exhaustion of local remedy clause, where domestic arbitration, domestic courts will enjoy much powerful authority rather than international arbitration. So is it the time that India can seriously think about ICSID as well to cater some sort of confidence in the foreign investors? So this is what the general idea is, where I have concluded that the point of ICSID is not even being under consideration for India. Looking into the SSDS mechanism that India has lastly taken into its BIT. And the other part of jurisdictional limitations have only increased serious problems in the minds of investors with respect to investing in India in a very free motive. And that is why in the last 6 years, we could see only 6 BITs that India could manage to sign. So that's all about the paper, which mostly discusses about the regulatory restrictions that India has imposed to enjoy its freedom.
Thanks very much, Animesh. That's a great summary, and I think really just conveyed the issues you're discussing and your approach. Now, if I could just ask, Eric, would you like to start with your comments on the paper?
Yeah, it's perfectly fine. Many thanks, first of all, for inviting me. It's really a pleasure to be here and to discuss this paper, which touches upon the Indian model BIT, the sort of model text that India developed some time ago, has always been relatively interesting until it was used. The question was, what does it actually say about the directions investment law is going? And I think you discuss it quite interestingly in light of the practice. The first thing we see is, of course, that a model is a model, and you never find it in pure form. Right? So, and this is why I think the example with Brazil is quite interesting, because contrary to the other BITs or recent BITs that were signed by India, the one with Brazil indeed doesn't have investor-state arbitration for now. The question then, of course, is it really India's policy or more Brazil's policy, right? So it can also, we know that Brazil has never been a very big fan of investor-state arbitration and investment laws protection standards generally. So you always have this balance, of course, of looking at the different negotiating states and see which one actually, this probably also meets India's expectations, right? So it's a nice combination. But I want to take a sort of opportunity of the paper to discuss perhaps or launch some ideas more generally of the whole debate. One important theme, I think, is the link between substance and procedure. So you focused mostly on investor-state arbitration, and this is interesting, your second title is protecting the regulatory power of the host state. So in your paper, and this is something that's, of course, present in most debates, is this connection between substance and procedure. Now, in principle, I mean, I would say traditionally in international law, there's a relatively strict distinction between both. You have the obligations, and then by the very express and perhaps also extreme consent-based system in international law, the existence of rights is never coupled to a procedural right to enforce these. This is really typical to international law. You can have a claim in a violation of the use of force, but you never have a form unless there's consent. And it's a bit the same here, of course. You can make the connection also with human rights claims. Interestingly, investment arbitration, it tends to be blurred because we combine both, right? And you also do it. I still think it's necessary or interesting to make sure that we look at them separately, but have to acknowledge the connection. Precisely because states do so. They say, and India is a perfect example, we want to protect the regulatory space or power of the state, hence we get rid of investor-state arbitration. But that's one way to do it. There's other, right? Others are limiting the standards, and this is also something you discuss, but keeping, for instance, the right to a remedy, investor-state arbitration or anything else. But I think it's quite interesting how the substance and the procedure is really intermingled. And it's not exceptional. You see it also in interstate cases like the Nicaragua case, where the US backed out of the optional clause declaration before the International Court of Justice because it considered that the court was not the right forum to decide on its operations in Nicaragua. It's a bit the same idea. You want to keep the power to do something, and therefore you get sort of rid of the post facto evaluation of what you do. So that's one important thing. that I think is quite interesting in the debate. There's a bit, I have to be honest, a bit of a tendency to focus too much on the dispute settlement aspect. So the whole reform is really about arbitration being the problem, and the court, a multilateral court that will solve everything. I think it deserves more nuance, and you do it in the paper, right? So you really explain the link between regulatory power and access to arbitration. And then if we look at investor-state arbitration generally, I think, yeah, I've always defended the idea that in investment law and arbitration, states can pretty much do whatever they want. We're dealing with a field of international law, or even if you look at it from a hybrid perspective from private, which is relatively open to any possible variations. As I often say to my students, we're not dealing with use cogents norms or genocide. So as long as states do not include any references to these norms, you can pretty much do whatever you want. So all these variations you see, these additions of pre-arbitration requirements, limitations to certain parts, they're all probably justifiable. And again, from a pure voluntarist perspective, states can of course include these. There's just one element that I think is important in this debate, which consists of two elements. The first one is to bring it back to what it is states want. If they want to protect their regulatory space, all these limitations to arbitrations are not necessarily always the best method to obtain this. I think much can actually be done, as I said, by looking again at the substantive standards of treatment, right? Instead of adding all these layers of obligation of pre-arbitration requirements, which actually make the access to arbitration more difficult, while what it is you want is to restrict the application of certain standards in certain situations. So that's one element. The second one is that I think you still need, if you want to sign a treaty, it still has to make sense. And this is something you see in many of the debates, and I've spoken in the past years with many colleagues also from, and practitioners and also officials from other states. There is a bit of a tendency to say, I want to sign a treaty, but I want to get rid of a most favored nation clause. I don't want expropriation. I don't want access to arbitration. Fine, but then the question still is, do you need an investment protection agreement? So that's one big question you need to ask as a state, and also I think as an academic. And at which point does the usefulness of signing a treaty tip in favor of simply not signing a treaty and perhaps relying on custom? Because in the end, the usefulness of the treaty, and this is something India is probably also thinking about. The usefulness is, of course, to give investment protection and perhaps expand it to other fields like human rights. And India has been sort of very progressive in its model BIT, which is quite interesting. But the question then always is, well, if you have no access to investor-state arbitration and you limit the state-to-state dispute settlement clause to really certain questions of interpretation only, but not claims and sort of diplomatic protection, do you need really to sign such a treaty, right? Because it would then only be useful if the Indian courts can directly make reference to or apply the treaty. And I'm not sure it's always the case. It depends on the states. To be honest, I'm not familiar with the Indian legal system. So it might be interesting to see whether an investor could actually directly invoke the treaty. Then it's interesting to have specific standards. But if not, you can wonder whether it really in the end, makes sense to sign a treaty with rather extensive drafts if in the end you have no method to enforce these. So then there's a second point in this respect is one of the interesting achievements, I think, is precisely this access to justice over the past decades, generally in international law. You have more and more disputes settled, also in the human rights context. This is one field where access to justice is considered a problem. And I'm always using a quote, or at least a discussion by Judge Greenwood a couple of years ago in a conference, where he said, if we would simply replace investor-state arbitration by human rights, you would have a relatively similar system, but you don't hear the same concerns in the context of human rights because it's generally considered as good compared to investor-state arbitration. So again, this is relatively extremely put, but there is a question that I think is also underlying everything is, if you increase access to justice, why is it problematic specifically here? Maybe because the treaties are not well drafted, and this is what India is trying to change with better standards, more detailed standards, more requirements. But it's a broader discussion I think we need to engage in investor-state arbitration. So what does this mean, this access to justice? Do we need it? Do we not need it? And why is it specifically considered a problem? Arbitration exists because precisely states wanted to avoid domestic courts and exhaustion of local remedies. So we are reintroducing precisely what was being left out by investor-state arbitration. In part, it's always a bit more nuanced. Anyway, so I think it's a useful debate. It's very interesting, especially India, a huge country, has the potential more now than it has done in the past because of the general skepticism that sort of put India a bit in the back seat when it looked at investment reform, investment arbitration reform. Could take a much more active role. And the Indian model BIT, the recent one, was a great start. I'm happy also to see that it's actually being implemented in practice. Anyway, but I think the academic debate needs to be mindful of certain of these nuances, or at least the broader context in which it operates. But I much like the paper. It's very interesting, and I wish we would see a bit more on these recent treaties. So thanks very much, Animesh and Professor Arvind. Then happy to have a discussion also when Jarrod has given his comments.
Thank you very much. It was a very, very thought-provoking comments, and I'm sure there'll be a lot of discussion around that. But I'll first hand over to Jarrod for his views before giving Animesh a chance to respond, and then opening up the floor more generally for questions. There were already a couple coming through in chat.
Great, thanks Arvind. Thanks Eric for those introductory comments, or substantive comments, I should say first. And thanks to Animesh for writing a great paper. It's very encouraging to see engagement with India's model and with the future of investment law in India. As you might know, this is something that interests me. I've written a little bit about this myself in the past, and so yeah, very pleased to have a chance to comment on further scholarship in that area. So I've tried to organize my thoughts a little bit, and I think I've got four kind of big comments, four overall comments on the paper, which I'll start with, and then depending on time, I've got plenty more smaller things that we can get to, but we'll just see how we go. So I think just on the overall side, firstly, if to summarize the paper as I read it, I think that what you're doing is in parts 2 and part 3, you're setting out a descriptive argument. You're arguing that India's new BITs are more state-friendly, basically, than the older ones. And you had some criticisms of that here and there as well, and I want to say something about those later. But I think in general, it's a descriptive argument. And I don't mean that as a criticism. I want to clarify. We often tell our students description is not interesting. You should analyze, you should evaluate, you should give reform proposals and all this. And there's a role for that, but I want to offer some defensive description in relation to your paper, because I think that a descriptive argument can be really useful if you're describing something that hasn't been described before. So one of the contributions of your paper could well be the identification and the description of aspects of India's new BITs that make it state-friendly that have not been, previously appreciated in the literature. And I think some elements of your part 2 of the paper could certainly fall into that category, being aspects that at least I haven't seen in the literature previously. So I think that's a really valuable part of the paper. Part 4, as I see part 4 is slightly different. I think there you're making a normative argument, about why, in your view, India should join the ICSID convention. And, you know, tell me if I'm misreading your paper here, but yeah, I see part 2 and part 3 as being one type of argument, and then part 4 as being a different type of argument. So that's just kind of the first overall comment, just I guess setting out the style of argument that you're engaging in here, which might help you just to understand what you're doing yourself in the paper a little better. But then this feeds into my second comment, which is that at some times, to me anyway, I wasn't quite clear on how these two styles of argument fit together. You're trying to do several things in the paper. And I just wondered at some points how they fit together, whether they're consistent with each other. And I wonder whether it might be better, as you kind of take the paper forward, it might be better just to choose one tack, to either just choose the normative tack or the descriptive tack, and you know, concentrate the paper in that way. And I can talk about some examples later if we have time, but and again, maybe I'm misreading it, but just to give you one example of what I mean there, is I think what you're saying at some points is that you're criticizing India for making these state-friendly changes in their new BITs. But then I think in part 4, you also say that those changes will help India to be more comfortable in joining the ICSID convention. And please correct me if I've misunderstood you there. But to me, that sounds a bit like you're saying, well, I don't agree with these changes, but actually I do agree with them because it will help India to join the ICSID convention. And I think, you know, and I think that's a good thing. So it just felt a little bit like you were having it both ways. You're against the changes, but you're also supporting the changes. And, you know, that in a way brings out the tension, I think, for me, between parts 2 and part 3 on the one hand, and then part 4 on the other hand. A similar example, the enforcement section on discussing enforcement of awards in part 2. Again, I wasn't quite sure if that fitted with the rest of your argument in part 2. So, you know, just briefly, for instance, you say that the new treaties of India are clearer about enforcement than India's older treaties. I think you talk about a clause in there that says awards will be enforced, you know, in the domestic court system. And to me, that seems like a good thing for an investor. That seems like a pro-investor position rather than a pro-state position. Presumably, an investor would want a stronger assurance that the award will be enforced. So that's fine in itself, but again, I just wonder how it fits with the rest of part 2, which seems to be saying that these treaties are more state-friendly. Here we have one aspect, at least, where it appears to be investor-friendly. So that maybe just complicates your descriptive argument, right, about that these new treaties are state-friendly. So yeah, so that second comment is just to maybe take a bit of time to figure out how all the different bits of the paper fit together and how the different styles of argument that you make in the paper fit together. The third general comment that I had, I'll just forge on to that one, is I guess kind of how you deal with, and this is where we come to Eric's comments. I think this ties in quite nicely actually with what we've just heard from Eric. The third comment is how you deal with critics of this whole system. Because to me, it seems that you're clearly favorable towards investment treaties. You clearly support, I think, the idea of having investment treaties, having substantive and procedural rights for investors. You say at one point domestic courts, you know, are not good enough, they're slow, they're biased, whatever. So we need these international protections. And, you know, and for that matter, Indian investors need them when they go overseas as well. So your view seems to be quite clear. You're in favor of this system. Okay, that's fine. But there is a large literature out there which would take issue with that view, right? There's a lot of people who, you know, would question the whole premise that you're accepting here. It's very easy to get into the debate over where the balance should lie between states and investors. You talk about the fulcrum, swinging from one end to the other. But that all assumes that we should even have these investment treaties in the first place. And I think this is what Eric was suggesting as well. Is that really true? What purpose are these treaties serving? What evidence is there for why we have these treaties? And you don't have to write a whole new paper assessing that evidence, but I did feel like you needed to acknowledge that literature a little more directly, rather than just making a bold claim that India would not gain any foreign investment, if these treaties didn't exist. I'm not sure if you say that specifically, but that's kind of the impression that you might get from the paper. Is that really true? I mean, economists are not clear on the answer to that question, right? So I'd encourage you to just have those criticisms in mind as you amend this paper, and say something about them somewhere in the paper. I think that would strengthen the argument that you're making. Then the last overall comment that I wanted to raise was just the conclusion. I think you can be more bold, actually, in your final part of the paper. I think you can be a little more ambitious there. The final sentence is something like, it'll be interesting to see, what India does. To me, that's the kind of thing that you often hear from students in exam essays, right? They often say, well, there's arguments here, there's arguments there. I don't really know. Let's see what happens. And that's fine if you're a first-year undergrad. But it's your role to kind of tell us what you think, right? And I mean, Animesh, you clearly have views, right? It's not as if you don't know what the answer is, and it's not as if you don't have ideas and opinions and views here. You've set them all out in the paper. So I think you could just tie all that in and, really hit us at the end of the paper with where you would strike that balance between investors and states. What you think India should do. Tell us kind of, I guess, just be a little more ambitious with the final parts of the paper. I felt like the ending was a little neutral for my liking there. So yeah, that's my 4 overall points. Happy to continue, or maybe we just kind of pause there, Arvind, and I'll come to more specific points if we have time in the remainder of the session.
I mean, we have under 5 minutes or so if you'd like to make some of the more specific points you have now.
Sure, yeah, okay, no problem. Yeah, okay, thanks. So there were various more specific claims, throughout the paper that that I wanted to kind of jump on a little bit. These will be fairly specific things in the field of investment law. So, for any listeners without that background, I might be getting too technical here. But just to start with one example, in part 2 of the paper, you discuss the jurisdictional limitations. And you mentioned the first set, things like tax measures are excluded, local government measures. Sure, I'm happy with those ones. One claim that I wanted to pick up on, though, or to ask you about at least, was the claim about delay in enforcement of an award. I think you suggest that the BIT would not cover, jurisdiction over a claim for delayed enforcement of an arbitral award would be excluded by the model and by the new treaties. And I wondered about that because, to my mind, that would be a fairly clear denial of justice claim. And I would have thought that would be covered under the provisions on denial of justice, Article 13 in the model BIT, for instance, which is translated to Article 3, if I have it right, in the India-Belarus BIT, for one example. You don't have to, respond to that now necessarily, but I just raised an eyebrow at that claim. I think there might be scope for a denial of justice argument there. In a similar mode, you talk about the umbrella clause in that section. The model does not include the umbrella clause, and so you say that excludes jurisdiction over contract claims. On one view, that's right. I see what you mean. I agree with that. But I just wonder whether somebody might come back to you and say, well, actually, the umbrella clause is not really about jurisdiction. It's a substantive protection in the treaty. And so when you bring a claim under the umbrella clause, it looks a bit like a contract dispute. Yes, it looks like a contract claim, but it's not really. It's a claim for breach of the treaty under the treaty clause called the umbrella clause. And so, you know, describing that as a jurisdictional limitation, you know, I see the point, but it's a slight terminological problem for me to say that that's jurisdictional. Similarly, on just while we're on umbrella clauses, you refer to the phrase in the model, the reference to any other obligations. I think in the Article 3.2 of the model, you talk about whether that phrase would include the possibility of contract claims, I think. That text, though, for me, that text comes from the full protection and security clause in the treaty. And to my mind, what the model is trying to say there is that full protection and security only includes physical security, and what it excludes is legal security. You may be aware there's a separate debate over how far that clause extends. Does it include the stability of the legal system overall, what we might call legal security? The problem is that that word security is unclear in itself. Is it purely the physical, so that the factory doesn't get attacked or blown up or something, or does it include this abstract legal security? So the model clarifies that point, but probably when it's referring to those any other obligations, I think what it's trying to exclude is the possibility of a claim of legal security, rather than the possibility of an umbrella clause claim. So I hope that makes sense, but yeah, to my mind, when you suggested that related to umbrella clauses, again, I raised an eyebrow. I wonder whether that's quite what the model intended in that clause. Maybe I'll pick one more, Arvind, if there's a minute or two. Another, in part two still, another limitation on jurisdiction that you mentioned, Animesh, was the limit to the limit on the jurisdiction to review the merits of a domestic court ruling. That's a really interesting clause in the model. I've scratched my head for many hours over what that clause means. My conclusion is that it doesn't mean anything. I've written a little about this in some of my other work, which I can point you to if you're interested, but to my mind, that clause basically serves no purpose in the model at all. It repeats other clauses. At the most, it's redundant. At the least, it just doesn't really do anything. Maybe it looks good, politically to I don't know, pacify critics who are worried about international tribunals stepping on the toes of domestic courts. It might serve some symbolic purpose like that, but in practice, I don't think it does anything at all. So again, I just wonder whether you can correctly describe that as a limitation on the jurisdiction of the tribunal. I don't think it has that effect in practice at all. I can, as I say, I can point you to my views in more detail on why I think that. Maybe you disagree, but that came to my mind when I saw that part of your article. How are we going, Arvind? Should I feel like I should stop talking now, but give Animesh or Eric a chance to respond.
Yeah, I think I'll give Animesh a chance to respond. And there are a couple of questions from chat which we can raise, and then we can come back to your further points because there'll be more time. Eric.
Yeah, thanks. Can I just add two small points? Because I also had a list of smaller things, and Jarrod mentioned a couple of them, which I also noted. Also on the review of domestic courts, I think it's a very important point. I had the same as Jarrod. I was really wondering what this means also on the denial of justice. There's one additional point I wanted to make about the history, where it's all a bit more nuanced, I think, than what you explain. Notably, the sort of area or part where you explain that the ICSID was a sort of response to the NEO declaration and vice versa. It's really more complicated because the ICSID was actually discussed, negotiated relatively separately from the NEO, New International Economic Order, Permanent Sovereignty of Natural Resources, because it was really World Bank initiatives, and the other ones was really General Assembly discussion. And you see that the discussion were actually much more in parallel. So I'm not sure you can easily, they're connected, but one is not necessarily a response to the other. There's a great book by Taylor St. John on the history from a political science perspective, but she explains very well where the idea comes from. And you see that it's really sort of disconnected from the broader debate on the substantive investment law standards. And ICSID was also really presented as an ideologically neutral institution. We basically say, we just offer facilities to arbitrate disputes. We're not involved, and this is something you have to rectify at some point where you make the link with regulatory powers. It's not at all involved in substantive investment protection. So when you look at the history, I think you have to add more nuance or expand heavily. But then the question is a bit what Jarrod also explains, which direction are you heading towards? And this is a choice you'll have to make at a certain point to make a bit more clear. So that's it.
Thanks very much. Animesh, would you like to briefly respond to the comments you've got?
Yes. First, thank you so much, Professor Brabandere and Professor Hepburn. Firstly, I'll just, since I have made few stars beside the discussions on part 4 and enforcement, I'll just try to explain what was my point of view while I was trying to write down these things. First, with respect to part 4, why I have chosen this normative approach? Because at the conclusion of part 3, I have tried to emphasize on the fact that India has closed the doors for the foreign investors in getting their problems redressed in front of any international forums. So I was trying to argue now I have properly understood where the problem and where the mistake I have made on this, where I've tried to argue that since you have closed all the doors for the foreign investors, why don't you open a simple door? And the skepticism you had once regarding ICSID's point of views, because from the history of negotiation, what we could see that I have cited there, the Indian representative, they have always raised the questions on striking down regulatory powers with respect to going for ICSID, because ICSID will give a similar kind of position to a foreign individual at par with the domestic sovereign government. So this is where the problem lied. And now, since you have already rectified certain points, because you have placed so many checkpoints at several provisions, you can definitely offer investors with respect to redressing the dispute before ICSID. So that is something which you can find a positivity in the negative things that you have already done. This is what I was thinking initially. Now I will like to change certain things after you have pointed out that it moves to 2 directions. One where I have criticized these steps which India has already taken. And on the other hand, I'm trying to tell that these steps otherwise could be seen in a better way if India tries to go for ICSID. But at the end of part 4, in the conclusion part, I've also mentioned one thing, that ICSID's idea, like joining ICSID's idea, is no way been seen closer to India's mindset right now, because all the steps that India has taken has only been away from ICSID's, or rather away from joining ICSID. The decision is not towards joining ICSID. So this is where I tried to balance the argument which I posed in part 2 and part 3. That is number 1. Number 2, with respect to enforcement of award. Here, the point is, I'm saying that the new model BIT and the provisions both in Belarus as well as in Kyrgyz BIT, if we can see that it emphasizes on the fact that the domestic laws will be used in case of enforcing the award. But I have also tried to focus that there is no domestic law as such, because the point of arbitration, or rather the enforcement of arbitral award in India, is required to be done under the Arbitration Conciliation Act that India has. It nowhere accommodates the concept of commercial, this term commercial. And that was raised in 3 consecutive cases. One with the Louis Dreyfus, then in case of Khaitan, and then Vodafone, lately in case of Vodafone, where we have seen that Indian courts are taking different stands. They're not trying to accommodate arbitral awards within the meaning of arbitral dispute, which is explained in the Indian Arbitration Act. So therefore, despite giving a very accommodating enforcement provision in the model BIT as well as in the new BITs, India, on the other hand, is not accommodating enforcement through its domestic laws. So simply mentioning that we will allow you enforcement through domestic laws is not going to suffice. So there the BIT lacks a point, or rather, while I'm trying to criticize the Indian government, it lacks the point that it is promising in one hand, it will allow enforcement through the domestic laws. But on the other hand, the judiciary is in no mood to recognize the arbitration or the international arbitral awards which are passed in ISDS cases within the ambit of Indian domestic laws. So there is a void, there is a legislative gap between these two. So that's where the enforcement problem comes into picture. This is the second thing. So if probably I have not been able to make it more clear, I'll work on the wordings of it. But this is what I tried to make a point, that it's not at all helpful for the investors, despite being the language is quite clear at this time, because there is a legislative gap present. With respect to anti-ISDS point, I'm really thankful to you, Professor Hepburn. I was looking into Professor Trackman's work on ICSID under siege. So there I have seen that how ISDS is not taking the right thing in the right track, because most of the European Union is trying to evolve a new idea, and there is a point where most of the countries are trying to acknowledge the WTO system, which India has also done with respect to the SSDS provisions and the dispute settlement provisions in India-Brazil BIT, that there cannot be any compensation provided by the tribunals. It can simply ask the country to implement a particular obligation and change a measure. So it can only work on that, whether it is wrong or whether it is right, more into a WTO method. I will refer to this particular point. I'll just include more literature on this. And then regarding, yes, Professor Brabandere, you have mentioned that can investors invoke treaties in Indian courts? This is another implication from what I tried to make a point out of, that Indian courts are incapable. The reason is, if we take the example of Vodafone and if we take the example of Khaitan, in both the cases, they have stated very clearly that investment disputes are not commercial in nature, looking into the fact that they are directly filed against the sovereign. So that doesn't make it a commercial, because it moves into the domain of public international law. However, when we look into specific arbitration cases dealt by Indian courts, we see a very different kind of picture. They have not construed the term commercial so narrowly. So this is where I'm trying to say that Indian arbitral tribunals, in a sense, are quite competitive with experts sitting there. However, courts does not accommodate these experts. Even if investor gets an opportunity to invoke their breach of treaty obligations before Indian courts, it will take several years. It will take several years to decide on it. And it was evident in White Industries case. For 9 years, the case continued before the Calcutta High Court, after which they again moved for international arbitration, and finally it was settled. So this is where I'm trying to focus, that Indian courts are not yet that much competent to decide on matters. Besides the age-old debate that we have, that Indian courts are already overburdened with so many cases, crores and crores of cases are already pending. And over and above that, if we try to bring in international disputes, which is otherwise of international nature, then it will be difficult for the Indian courts to accommodate things. This is where my concern, that whether they can correctly invoke before the Indian courts. However, I support ELR clause not to the extent of 5 years, because many countries have started taking ELRs, which is fine. but it ranges from 6 months to 5 years. 5 years in the case of India, and 6 months to 1 year in several other countries. It is perfectly fine to invoke ELR in a particular BIT, but the extensiveness, this is what I tried to mention, that the lengthy ELR clause is a problem for India. Otherwise, it is fine. So this is where I would end my explanations to what I thought that I can afford. Other than that, yes, I can understand where Professor Brabandere said that ICSID and NIU, I need to do a lot of more readings on this. I will, for the time being, I will try to avoid that particular debate in the paper. If that is fine, I'll leave this to Professor Brabandere to suggest me whether I should leave this particular debate for the time being and just focus simply on whether India's, what was India's stand in the early consultative stage when ICSID was negotiated, not getting into the debate of whether it was because of NIU that India did not enter into. This is my part. I'll just now wait for the suggestions from both of you.
Right, I think I'll, are there any immediate responses from either of you to those comments? If not, we can do a round of questions from the floor and then come back to that.
Go ahead.
Go ahead. I'll go after you. Go ahead. I'll go
Oh, sure. Okay. Yeah, well, just on this history point, thanks to Eric for raising it. I wanted to say something briefly about it as well. When I tried to look at this myself a while back, the main reason that I found for India's reluctance was the fact that international law would be substantively governing the dispute, or at least that possibility existed at ICSID. From what I could tell, India's concern really was that it was not domestic law that was governing these investor-state disputes. The possibility was of substantive rules of international law coming in, more so than the procedural problem that you highlighted of placing investors and states on the same level. Because India was already doing that. It was already granting arbitration rights in contracts to specific investors in commercial arbitration, but against the state at the ICC or under UNCITRAL rules or somewhere else. And that would already, it's the same arbitral rules that we use more or less in treaty-based claims. That would already place the investor and the state on the same footing. And it seemed to me that India didn't really have a problem with that. It was more the substance of the rules, actually. But, I'm open to be corrected on that if there were other reasons as well. Thanks.
Yes, if I can also briefly add, ties in with what Jarrod also explained, but when I listened to your reaction, Animesh, it's very difficult, of course, in this debate to say whether investment treaties are good, bad, needed or not. But you have to not necessarily take a position, but I think acknowledge that what Jarrod also explained, there are people who deny, and they have good reasons, any value of investment treaties to attract investment and hence that they are economically necessary. There are others who oppose it because for political considerations, questions of sovereignty, whatever. There are then others who consider nonetheless that it's a good, and you're mostly in favor of treaties, but not entirely also. I think you're a bit more nuanced. But there's, of course, one, and this ties in with your reaction on domestic law. There is the sort of theoretical logic, legal construction of why arbitration can, in certain cases, be good, because courts take a long time, are not necessarily competent, etc., etc. Right? So these make sense to then offer arbitration, but it's a very different debate than whether politically, economically, it's necessary, and it ties in also with what Jarrod said. You have also clauses that are inserted just to soothe an internal criticism or opposition. I'm from a country, I'm Belgian. Trust me, we have also different states within the federal government. Some, the north, much more in favor of investment treaties, the south, very much opposed to it. And then you see that treaties have clauses that clearly are aimed at soothing the criticism on one side, not the other. So all this just to say that the sort of straightforward, this is good, this is bad, is not easy in our field. And it's a very good to make a logic legal argument, but you have to acknowledge the opposition from other fields as well, and vice versa, I think.
Thank you very much. I think that last point is particularly important. You are making a legal argument, not a purely normative argument. There's a legal analysis underpinning it, which distinguishes it from people who simply argue on the basis of principles of sovereignty or other highfalutin notions in political theory. And I think because of that, you shouldn't fight shy of saying this is where I stand in the debate, even though it's a pretty charged debate, as you know from the literature. Right, I don't actually want to abuse chair's privilege, but so I will simply start calling on the others who have questions. Firdaus, you'd raised a question in chat. Do you want to raise it in person?
Yes. When I read thank you for the article and the opportunity. When I read the article, the first I understand the Indian bit went on transformation, but I wonder whether the issue behind the transformation is only because of the regulatory restrictions which the author is speaking in rest of the paper, or is it something else also they are behind that? And say, for example, going beyond the as a structure of the bit, when it is between the developing country as a host country, and who is very weak in terms of bargaining power. So can that cause to some problems because they accept some projects later that went on a loss and or it cost the sovereignty of the country, and later it creates a lot of disrepute between the parties as well as among the countries, or else is there any other problems also in the same in the subject of transformation? And also, I think others also raised the question: to what extent does the disputing party itself have the regulatory power to resolve? Will be a healthy model for a bit? These are the questions of mine. Thank you very much.
We'll take a couple of questions and then you can respond to that, Animesh. Dinesha?
Thanks, Arvind. Thanks, Jarrod and Eric, for those responses to Animesh's paper. And Animesh, thanks for the opportunity. As most of you here know, I come to this as a pretty much a lay person from a public law perspective. But again, I think as some of you may know, this is becoming a hot issue for those of us in public law, and we are realizing that we need to learn more about how concepts and debates in the law of investment are going to really impact or already impacting public law. I think my colleague Dilini is here. We've had this discussion. So I came at this paper from that perspective. So my comments, I don't really have a question. My comments are from the perspective of someone who is interested in the subject and reading this paper. So these comments might help you to sort of probe further on the comments made by Jarrod and Eric about substance and scope. So the first question, of course, is who is your audience? I was not very sure about that when I read your paper. I wasn't sure whether this was for the investment law buffs, but whether you were also seeking to reach those of us who are outside of that constellation. So related to that is the other question about your agenda. As the discussants pointed out, I was asking myself, so what is the author's commitment here? Where are his intellectual commitments? So that is something for you to think about, and perhaps maybe you could use your introduction a bit more productively to do some of this work for you, so that your audience or your reader will be able to have a conversation with you as they read your paper. Related to that is the perspective. Whose perspective are you interested in? Are you taking into account one perspective or multiple perspectives? Again, would be helpful to know. the history point was already flagged. I saw two perspectives, the grand perspective of history, but I was also curious about the detail. So you talk about how India has approached some of the what seem to be certain settled practices in dispute resolution, and it has carved out its own way. But why did it do that? How did it manage to do it? It would be very interesting for someone to know why India has chosen to make the decisions that it has, particularly in relation to its drafting. So the grand aspect and the specific aspect. In terms of scope, I found your paper to be quite rich. It definitely has the public law aspect, it has the international law aspect, and it has those very specific investment law related aspects. And I felt like the weightage, it wasn't clear as to how much weightage you wanted to give the different aspects. I, of course, would be very interested in learning about the public law aspects that you talk about, particularly the judicial confusion that you refer to, etc. But as an author, if you could make those decisions when you revise your paper, I think then you can decide as to what you want to keep in this particular paper and perhaps leave for your next project. So those are the comments I had. Thank you.
Thanks very much, Dinesha and Firdaus. Animesh, if you want to briefly respond to those.
Yes. First, Dinesha, thank you so much. This is a much required part. Since I do not know, I have not yet planned for sending this to any journal right now. I am looking for first developing the paper the way both our discussants have said. So it will be helpful for me to develop a perspective also for those who are not so much into the subject, who are a bit loosely into the subject, those who belong to the public international law domain, but not into investment specific. I will definitely look into all this a few things. With respect to the other question from Firdaus, I'm not quite sure about what actually he wanted to mean by looking into the other perspective rather than into the regulatory power. From my understanding, what I tried to work upon is to restrict myself into one particular topic, which is already, I have not been able to do it quite extensively, as Professor Hepburn has already told me that I've looked into multiple directions. But if I try to look into something else beyond regulatory power, but into something else, it will become more of a monograph. I just want to restrict myself into a very small kind of work. Still, it's more than 9,000 words. I just wanted to bring it down to something less. And now I have these opportunities to strike down the historical parts and lessen it. But again, to very minutely giving, very precisely giving an answer to Firdaus, yes, there are certain other aspects, but with respect to ISDS, why a particular government looks into or what it actually demands from, you're right to point out the developing nations and the least developed nations, they are quite cautious of while they take steps. But for Indian perspective, from the point of view of India, what India did it from its earlier experiences. In the last 15-20 years, India has suffered from 24 BIT claims, and in most of the cases, at least in 20 cases, India lost in the sense India was the party who is a respondent, and in 5 cases, India has suffered $1 billion compensation. So this is where the perspective is, and with respect to negotiating the treaties, India has always done with both developing as well as developed nation, but its situation was as such that it relied upon the UK BIT, which was more of a capital exporting BIT rather than a capital importing, which is India's status right now. So from that perspective, I have looked into a very small point of discussion, not into the larger one. I think Professor Hepburn would like to add something.
I'll ask Dilini to comment first, since she had her hand up first before going back to Jarrod. Yeah, we are a little bit over time now, but if people don't mind staying on for a few more minutes, I think it's quite an interesting discussion.
Thank you. May I proceed? Thank you. Thank you very much for this interesting paper. And what I got your point is the main argument is like India's approach towards investment protection and the ISDS is going toward the protectionist approach. And the main reason for that is the India's need to protect its regulatory power. So my first question to you is how you would analyze this approach in terms of Indian investors' perspective, because we know that there are few cases where Indian investors has also used this ISDS mechanism to successfully win the cases against some of the foreign governments. So how would this approach impact on the Indian investors' perspective? That is my first question. And second one is, some of the authors like Prabhash Ranjan has very clearly pointed out that India should continue with the ISDS process because most of the cases so far that has been filed against India is not the Philip Morris-like cases. Because it means that these cases have some impact to regulate the Indian government behaviors, who was not that much consideration of their international investment obligation. Because from South Asian countries, I know that most of our government doesn't have any sense about what is the legal impact of these bilateral investment treaties, and they focus on sovereignty. But at the end of the day, they don't have any sense that they have trade off their sovereignty in terms of signing these bilateral investment treaties. So my second question is how you would respond to this kind of argument that the India should continue with the ISDS because most of the cases are not the Philip Morris-like cases against so far the cases that have been filed against India. So these are my two questions to you to further elaborate. Thank you.
Let's take two questions. Jarrod, if you'd like to give your comments as well, and then we can get back to Animesh.
Sure, thanks, Arvind. It was really just tying in Dinesh's public law interests and maybe Dilani's as well. In relation to part 3, Animesh, when you discuss compensation, again, I think here there's a possibility to give greater acknowledgement to the other side, or the counter arguments. Because, I mean, I'm not an expert in Sri Lankan law or Indian law, but in many systems of domestic law, domestic public law, you would not get compensation for a measure of the state if you challenged it in administrative law. You might get some kind of prospective quashing order, but you wouldn't necessarily get, retrospective compensation. So in that sense, they're similar to the WTO model. And both of those are different, right, to the investment treaty model. And so the onus is kind of on you to justify, arguably, to justify why you should get retrospective compensation in this presumably public law system where that's actually quite strange if you look at, domestic systems. And so that there's scope again, I think, for you in part 3 to just appreciate what you're assuming here. That there's somehow a right of compensation for investors. Who says that's true? Why do they deserve compensation, actually? You might want to look at some recent work on compensation in investment law that's starting to ask that question. How much are we giving these people and on what grounds are we doing so? Not the legal grounds, but the theoretical or the normative grounds. That's all, thanks.
Although if there's a public law link to be made, isn't the compensation linked more to some of the takings jurisprudence in public law in relation to compulsory taking and expropriation? Because that's where some of this comes from, in any event, at least at the turn of the previous century, with the Turkish bonds and those cases.
Yeah, that's true. I mean, at least under Australian law, if you lodged a takings claim here under our constitution, you might get the order overturned, but you don't get compensation, right? It's not an order for compensation. The order might be overturned, and then the government retakes the order, this time paying compensation. So perhaps indirectly you do, but the court directly would not order compensation. And I suspect that that's true in many other domestic public law systems too. Maybe the Belgian can advise and the other jurisdictions that we have on hand, but that's my impression anyway.
I can confirm it's the same in Belgium. Yeah, I mean you can litigate in administrative courts if the government doesn't meet the standards for direct expropriations, for example, because compensation is not high enough. But then indeed it's squashed, and then the government would take a new order. There's just want to point out there's an interesting chapter. There's a book a couple of years ago by Stefan Schill, Comparative Public Law, and it has a whole chapter by, I think it was Anna van Aken, on remedies or compensation, which is very interesting because she makes a point relatively similar to Jarrod, which I think really goes to the heart of the debate, whether the compensation and the question whether you can, or you need to change it by sort of more WTO-like or administrative law type of sanctions, which states in principle don't like, because in the EU model or the EU treaties, there's a prohibition by arbitral tribunals to make orders to the effect that legislation should be repealed, etc. Anyway, it's an interesting debate, so I'm not going to hijack the debate myself, but I think Jarrod made a very good point on this also.
Thanks, Animesh. Now your responses.
Yeah, first I'll go with Delaney's first question: how to analyze from the Indian investor's point of view. If you look into the conclusion part, Delaney, you'll find out that I have mentioned something called a boomerang effect. So if Indian model BIT is being followed, or what is being followed right now, all the 6 BITs that India entered into, it essentially does not give Indian investors a chance to stand, since you cannot assume that there is any kind of domestic laws, because you'll still be treated under a similar kind of environment, like you are treating the foreign investors in India. There'll be a narrow space for ISDS. There'll be a limited scope for approaching the international tribunals, and then you have to wait for a very long time. If you can successfully negotiate on the terms that you have mentioned in ELR, then you have to wait for 6 years. So Indian investors are going to face a similar kind of challenge in foreign countries. And this is one aspect I've tried to highlight in a very brief point, since this is not the central part of my argument, in the conclusion that since it is increasing day by day, India is going for outward investments. This is a point which India must look into. And if it at all thinks of amending the model any farther in coming days, then it must take this thing into consideration. It cannot simply stay back in the seat and argue that I am a capital importing country rather than an exporting one. It is exporting. Make in India is a project which India tried to make things in India so that it can, at a later point of time, export things outside. So this is going to hit hard the Indian investors as well. That I have mentioned in my conclusion. With respect to whether we are moving towards ISDS, I have strongly mentioned the point that yes, India should move towards ISDS, because I could not make myself clear in the last part, which Professor Hepburn has said, I must take an ambitious move rather than being a neutral spectator, waiting for something to happen in the future. I'll change that part, and definitely I'll give my points. I was a bit shaky in giving the points, but this time I'll do that. Yes, ISDS is what I am in support of, but not in the sense which is being followed by most of the developed nations so far. Because as we know that even ICSID is trying to amend its provisions because of the fact that there is a huge kind of discourse going on, because of the fact that we have given a lot of powers to the arbitrators who takes decisions on the sovereignty of a particular state, like whether a particular state should take decisions or not, whether a particular state should do this or not that. That is being decided by an individual who wakes up one fine morning and takes a decision. This is an argument which people like us who are moving through this particular stage of transition, that there is a strong argument in favor of ISDS. There is a strong argument in opposition to ISDS. We are looking into both the things, and then for me it is somewhere which Professor Hepburn was trying to say, that you're trying to balance the fulcrum. Yes, this is where the debate will continue for balancing the fulcrum. I'm trying to look into that, whether we can move to a situation where we can balance the fulcrum and not totally go away with ISDS, because that's not an option. If we are asking a particular foreign investor to invest in India, or in, for that matter, any other country, taking the point of view of an Indian investor, it is important that we give them a chance to arbitrate in a tribunal which is free from any biasness or any kind of partiality that can be some prejudicial point in case of in a domestic court. So this is where my argument is that yes, we should move on with ISDS, and that is where I am also critical about the India-Brazil BIT. That SSDS is not what we are looking for. It takes us back in time. And coming down to Professor Hepburn's point, rights of this is again, thank you, Professor. I'll just look into this part. I missed this part, whether investors should be compensated or not. I have not looked into that. I'll look into that jurisprudence and I'll try to include that part.
Thanks. Sharima has a comment in chat. Would you like to make it in orally, Sharima?
Hi, thank you so much. So just a last point, since all the discussions, somewhat, I think all the concerns were raised and the discussions came up really good. So just thinking from an economic policy perspective, so when we say that India is actually taking a very protective approach towards ISDS or foreign investment, so I think it would be interesting to see in this particular paper an argument or a discussion of how would India be dealing with the quote-unquote eagerness or trust issue of foreign investors more when COVID-19 and the post-COVID-19 economic recovery, or eagerness to attract investments which are going off from Japan or around the world. How would this be actually come into play? So I think this is something I would actually want to see in this paper, since it's discussing about India's approach towards the foreign investors and foreign investment for a couple of years. So I think how would it be harmonizing with its future economic policies, and is it actually desirable, or is it just a result of sudden lumps of ISDS that are coming against India? I think this is something that would, if it's made clear in this article, the whole picture would probably be more clearer. Thank you.
Animesh, do you want to respond to that?
Yes, Prof. I just took that point. I'll just keep that in mind. But I doubt whether it will be right to take COVID-19 situations in this particular paper, because what we are discussing more from the perspective of the regulatory attitude of India. And the last BIT India signed is much before COVID-19. It is in 2020 January with Brazil. So I don't know whether it will be possible, but with respect to the economic goals, economic policy goals of India, I'll definitely try to look into it.
Thanks. Are there any further questions? It's been a fascinating discussion. Are there any further questions or comments? Well, thank you everyone for your time. And thank you, Animesh, for putting this paper forward. I think it's really led to a lot of this. One of the fascinating things about this is the way in which we bring different things together: public law, private and international law. There are also, I mean, Animesh, I'll get back to you separately on this. I don't want to abuse chair's privilege, but in the early history of investment arbitration, there was a lot of influence from private law and Roman law in particular. And I think if you're going to start looking at the balance with public law, I think looking at public law, private law, and investment law all in a round will really help flesh out some of the claims you're making in your article. But I'll email you in person about that, because I don't want to drag this out much longer. So, well, thank you everyone for your time. Thank you, Animesh, and thank you, Jarrod and Derek, for your contributions, and to everyone else who's participated in the discussion in other ways. As always, a recording will be available on YouTube in due course. Thank you all, and I hope to see some of you at the next session.
Thank you.
Thanks, everyone.
Thank you so much.